Okay, this is October 3rd. We are on Chapter 7. Oh, I had some additional questions on Chapter 6. We can go over those later. One of the questions that I had, it was a sort of an ethics question.
Which one?
It's not written, it's for Chapter 6.
Right, but it was on
I'll-
when
I'll-
you emailed, right?
Yeah, the one I mailed out last night or so. Your client says the monuments are gone.
Huh.
How much time can you spend looking for the originals?
I guess as much time as you can justify.
Yeah, it's basically, there are lots of different ways of dealing with this. You know, one is, he may be right, he may have knocked out the monuments.
Right, that's how he knows they're gone.
And we once had a client, well, not a client, but yeah, he, come to think of it, he was the client. He asked for a line to be staked. Staking a line is going down the line and finding the pins and marking, you know, like flagging and all
Right.
that. And he was dissatisfied with the work because he said that the pins were not in the right location.
Why did you hire the surveyor?
Then, well, because, well, actually, Brian and PJ, who was the manager of the business, you know, were scratching their heads thinking, what, how do you know that they're off? And, well, he had moved them when he put the fence posts in. And he wanted us to relocate the pins.
At where he had moved them from, or moved the monuments from?
Right. He wanted us to reset that line
Right.
at no charge. You know, because just staking a line only takes a couple of hours. You walk down, you find the pins, you mark them. You're not necessarily finding them with the instrument. You're not, you know, you're finding the monuments that are there.
Right.
You're not checking things. There was no reason to check the work.
Right.
So, yeah, he got disabused of the notion of a free survey pretty quickly. But I have to, you know, admire the gall. But, you know, there are major issues with, you know, what is you know, how much time is ethical, you know, and at what point are you doing minimum standards, and at what point are you beating the client to death? And you know, part of the question is, you know, what does it take to find the originals? And in the Evidence and Procedures book, he says flat out that you can predict a lot of things in surveying, but you can't predict the amount of time that it takes to find the monuments.
Right.
On the ground, in the ground, lying on the ground on their side, you know, which happens all too frequently.
Right.
But yeah, that's an ethics question, but it's also a you know, basic competence question. You know, if you have a crew, for instance, that's coming in, spending 6 hours finding points in a subdivision that was built 10 years ago, perhaps you have the wrong crew. So it's hard to say, but
Maybe the crew setting the pins didn't set them all.
that's
Just said they did.
entirely possible. That now it's a major infraction to say, you know,
Say that you did.
to
and
say
not
that you
actually
did,
have.
and actually, you know, you're not even supposed to say that you did
Until you get done.
do.
Gotcha.
So that used to be the great out. Well, we never got back there. And you know, from a business perspective, they're really, you know, it's easy to say stop by that place, set the pins later, a month later, or something like that. But from an ethical and business viewpoint, it's not ethical to seal the survey saying that they were set.
If it hadn't been done.
Yeah. Major oopsie. Okay, good. You've got Black's Law dictionaries right there, and you're probably going to need them.
Okay.
What is presumption? Well, try it without the dictionary first.
Presumption.
You certainly will be answering questions like that in a few weeks.
I know, but I haven't looked over my.
Okay. That's definitely vocabulary.
Presumption of what though? Because there's
Well-
like a bazillion.
That's the thing.
Presumption, a legal inference or assumption that a fact exists based on the known or proven existence of some other fact or group of facts.
Yeah. In other words, yeah, we presume that we're going to act on the assumption that this is true. How many different kinds of presumption are there? Start counting.
1, 2, 3, 4,
Yeah.
5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21.
Okay,
27, 28, 29, 30, 31.
and
In
that's
here.
just that
Yeah.
edition of Black's. Basically, there are
Oh, I'm sorry, 33.
33.
No.
The most important, well, you can keep going.
Yeah.
The main point is there's a bunch.
Okay. Yeah.
Yeah. So lots and lots of, basically, it's kind of like easements. There's an easement for almost any circumstance, and if there isn't, there is
Someone's gonna
now.
make one, yeah.
But one of the more important presumptions in civil law and in surveying in particular is a rebuttable presumption. Okay, you get a patent from the state for
Right.
land. It is presumed, it is assumed, the surveyor who turned in the work, the official county surveyor, LSLS, etc. It is presumed that he actually did the survey on the ground, whether he did or not.
Because he said.
Because
"Here's
he
the
sealed
survey."
it, he signed it,
Okay.
that's that. If you can demonstrate that he did not, and that's an uphill battle, if you can demonstrate that he did not, then that is a rebuttable presumption and you have rebutted it.
Okay.
So that's the one that you're going to see a whole lot in this book.
Right.
There are lots and lots of different presumptions, and the civil system could not exist without presumptions. Big presumption, the presumption of regularity. That's that if a cop pulls you over, you have to presume, you have to assume that he has a legal right to do so. You must pull over. If an officer of the court serves you with a summons, you must accept the summons because there's the presumption of regularity. Sometimes that presumption of regularity gets really stretched. So, but that's one of the things that keeps the society functioning, is the presumption of regularity. I think I need to close that. Sounds like somebody's unhappy. There we go. I know just how she feels. Okay. What is the difference between a boundary suit and a trespass to title suit? Did you read chapter 7?
No.
Oh, okay.
Is there a difference? Oh,
There's
is
big
there?
difference. Well, there is a difference. It's kind of like if there weren't a boundary issue, there wouldn't be a need to try title.
Okay.
Uh,
What's tri-title suit? What does that mean?
that's in there. That's in civil practices and remedies.
Okay.
That's where you find it in the codes. But that is where the aggrieved party, in other words, the one who actually has title to the land attempts to legally regain possession. Someone else has possession of it. And a trespass to try title is governed by, remember what we talked about, the limitation.
Right.
You only have so much time to do
Before
that
you can-
before the clock ticks out.
Okay.
So the person who is getting dispossessed of their land institutes a trespass to try title.
Okay.
The person who is possessing the land never does. Doesn't have to.
Could be that's the person that's attempting
Adverse possession.
Okay.
Yeah. So basically, the trespass to try title has to get in gear before the adverse possession takes effect.
I see.
And basically, the trespass to try title is the peaceable method. Now, this is about peaceable occupation of land.
Right.
What if they show up with shotguns and barbed wire?
The person who's attempting adverse possession, or the person who has the title?
The person doing
Doing the
adverse
possessing?
yeah.
They're going to have to get past my shotgun.
Well, no, the thing is, trespass to try title and adverse possession are civil remedies.
Right, but you're saying if somebody changed
Shotgun is criminal trespass.
so then you can call up
You
the
call
sheriff
up the
and
sheriff,
say,
you call up.
"Hey,
Actually, the
these people
JP
are
is a
coming."
great person to get to know in smaller jurisdictions because they have all the power of the sheriff and hardly any of the red tape. But no, this is where you get, surveyors deal with civil. JPs and police deal with criminal. And possession by force is criminal. Trespass, criminal trespass.
Okay.
Slightly more than hopping over the fence to check the boundary line. Or, the neighbor kid crossing your land to get to your fish pond. But no, this is all about under peaceful circumstances. When the shotgun is involved, it's now criminal, and that's beyond the scope of anything that we're talking about here. Okay. Now, basically when you do a trespass to try title, you're simply attempting to, you're dealing with who actually has the title to it, but without knowing where the boundary is, you don't have anything to decide. The jury
the plaintiff
does.
would need to have the deed
Well,
or the description.
okay, here's where it gets interesting. The person with the trespass to try title, even if they have the deed in their hand, has to prove their title conclusively.
Well, how would you do that?
Good lawyer, you have to have it surveyed.
Right.
So it has to fit in the deed, your deed description.
Be able to start at that point, find
Yeah.
all the things that it
Yeah, basically
names
it
as
has to
monuments.
be yours already. If you're attempting to adversely possess something and someone rolls the barbed wire around it, they've kind of messed up your plans, haven't they?
So, in that tri-title suit, the plaintiff would be the person who actually owned it. The defendant would be
The one who is possessing.
Okay.
Yeah. And what the plaintiff has to prove is that, and here you get into different questions. This is not a criminal case.
Right.
So you do not have to prove beyond a reasonable doubt.
Right.
You have to prove, this is the preponderance of evidence. This is the best call we can make.
Right.
So, in a trespass to try title suit, plaintiff has to prove his case. The defendant has to prove nothing.
Okay.
The best in a case like that, the best defense is often silence. we're kind of jumping ahead in the discussion here. The venue for all title cases in Texas is
District court.
yeah, and I downloaded that. There was a great UT website. There it is. It's in blue.
Okay.
So when you get the email, click on that website in some of your vast spare time, and what it gives you the skeleton of the court system in Texas.
Okay.
And what's amazing is all these little courts that exist too. You know, like you got your JP court, you've got municipal courts, and then you've got county courts. So it's district courts are way up. That's basically for felonies and for major civil issues. And then if you lose in district court, then you go to Court of Appeals or Court of Criminal Appeals.
Okay.
And then what is it? Or
Is
actually,
that
there's
state?
you go to appellate court,
Okay.
which are larger districts.
Right. So there's still a step in between district and, say,
And
state.
the state, basically, state Supreme Court is civil. And then the Court of Civil Appeals, or Court of Criminal Appeals, is the Supreme Court for criminal cases.
Okay. State-wise.
Statewise, yeah. That's as high as you can go in Texas.
Okay.
But you've got appellate courts, and they can take either criminal or civil. But so that's the intermediate step between the district court and the two, Supreme Court, Court of Criminal Appeals. Some very interesting survey law cases have been decided in the Court of Criminal Appeals.
Why would it be? I mean.
Why?
Because someone has
because they had a good
committed criminal.
judge there, and his docket was emptier than the regular Supreme Court. And that's there's no rhyme or reason. If you've got a good judge, use them. And God knows some of the. When you look at what is required to be a judge in the state of Texas, it's kind of depressing.
Is it not much?
You have to have your law license, and you have to practice for like 5 years or 10 years.
And that's it?
That's it. So, yeah. So anyway, is that thing still running?
Mm-hmm.
Okay. Okay, we talked about what is the difference between civil trespass and criminal trespass.
Right.
So basically, the person who is attempting adverse possession or is simply ignorant of the boundary line is the defendant.
Okay.
The person who thinks they have title is the plaintiff.
But then they have to prove it.
Yeah. Now, here's the interesting case that it brings up in the book, and you will read chapter 7, yes. But, okay, you are hired to do a survey of someone's property, and you find out that they are using quite a bit more than what their deed says they should.
Okay.
Those people are under no judicial requirement to notify their neighbors that they're adversely possessing their land.
Really?
Because it is assumed it's your land and you are responsible for knowing the boundaries.
Okay.
That is the presumption.
And because you have privity to your client,
You
can't go over
not
there
only
and
do
tell
you
them.
not have an obligation, you have an obligation to keep your mouth shut.
What if?
If you are an LSLS and your client is keeping under fence state land, school land, or things like that,
Right.
you then have an obligation to inform the GLO.
Okay.
That's
But if you're
the
just
difference.
an RPLS, you don't?
RPLS, no. Not if
Not
they're...
even if it's state land like that?
At this point, no. That is my understanding. You are not under.
What if they were growing something illegal on it?
Well, that's criminal. So you...
So then you're bound
Yeah.
to tell.
Well, I don't know, but generally you don't have to worry because things like that get found out pretty quick anyway.
Well, but I'm just saying, you know, there's 100 circumstances
Yeah.
that you could never guess.
So, yeah, like
Okay.
Breaking Bad and Waxahachie. No, it's hard to keep things secret in a small town. I remember driving out to one survey that Marvin and I did.
Mm-hmm.
And as we drove up the driveway, they had a little garden plot there. And they weren't growing sunflowers. And it's like, well, okay. It didn't look like they had enough to, you know, for distribution.
So, yeah.
Yeah, of course, it all depends on how big your habit is. Okay. Standard of proof in a trespass to try title suit. That's in there. And it's basically convincing proof. It doesn't have to be the criminal beyond the shadow of a doubt or beyond, reasonable doubt.
That's what I was going to ask. What's standard of proof? But
Mm-hmm.
I'll find it.
Yeah, it's in there. If a case in a district court is appealed, it goes, appellate court, yeah. And then from there, it could proceed to the Supreme Court Supreme Court for civil cases. Rarely, but it has happened. It did go to the Court of Criminal Appeals, and that was, I think, just judicial economy. He could take the case. Now, if it goes to appellate court, then the decision of the appellate court affects only the districts that are in that appellate jurisdiction. It's not statewide. Why is this important to know?
I'm trying to think of an example of why that would be, and I don't know.
Okay. You got a case,
Okay.
and there is a perfect precedent for it in another district.
Okay.
The other district, their rulings are a guide to, but not binding on,
Right.
your district.
So you could say it worked really well
It
over
works.
there when they
It works
decided
really well
this.
over there, but it's not. Their decision is not binding. Courts like to agree with previous decision, and that's
Right.
that's
If
called
it's within their
that's called
jurisdiction.
stare decisis. STARE. That's just Latin.
I know.
Stare decisis.
DECI, what?
DECISIS. And that means to stand on the decision. So, if it's in the district, then they can simply follow it. If all of the issues are the same, they never are.
Sure.
We'll probably go to that website. It's a good website. We'll have enough time. Wall v. Carroll, page 289.
Okay.
And when I say memorize, yeah, I'm serious on that. It's not that hard.
Oh, okay. I see.
Yeah.
Okay.
Trespass to try title is a suit to recover possession of land that has been lawfully withheld. So, no shotguns.
Right.
That's criminal. It establishes effective procedure by which rival claims to title can be adjudicated by a person who has the right of immediate possession. To maintain trespass to try title action, and that's the only remedy. That's the remedy for title issues in Texas.
To maintain trespass
is-
to
yeah,
try title
yeah.
action.
Plaintiff must have title to the land sought to be recovered.
Oh, okay. That's what we just said.
Yeah.
Okay.
Plaintiff's right to recover in trespass it depends on the strength of the plaintiff's own title, not the weakness of the person doing the possessing. Defendant is not required to show jack. although, and the thing is, you can prevail by the other person
Not
failing
being
to
able-
prove title, and then someone else, like the other adjoining property, might pull the same trespass to title suit against you. So there's nothing to prevent, once you prevail in one title suit, that does not prevent someone else from suing you or adversely possessing.
I was going to
or
say,
anything
so
else.
that trespass to try title, if the person who has the title cannot prove that they actually do,
Then
that
someone
doesn't
else might have a
necessarily-
better title.
Right. It doesn't necessarily mean that it has been adversely possessed and you have succeeded in that.
Yeah, that doesn't perfect the
They-
defendant's title.
Okay.
That only proves
It only
that
proves
the
that that guy
plaintiff
didn't have his-
didn't make
didn't
a
have
case for it.
Okay.
He might have had it, but he didn't make a case for it.
Okay.
The legal system is based on deciding only between two parties.
Right.
There might be a third party with a better claim.
Okay.
And that's a case that Ken Gold brings up here
Okay.
towards the end of the chapter. Okay. Yeah, here it is. Party that unilaterally resurveys property and finds that he or she has more property than previously believed cannot place duty on party whose land would have been taken as a result of the resurvey to bring any type of suit to correct the discrepancy. Is that estoppel?
Party that unilaterally resurveys the property and finds that they have more property than previously believed cannot place duty on the party whose land would have been taken. That's so confusing. I don't know.
So the point, what do you remember what estoppel is?
Well, I thought I did, but I can't tell you out loud. What yes, it is. I don't know why I can't think of anything.
There's an element to estoppel where you're in the wrong. You're like possessing someone else's land, and then based on mistaken belief, those people do something. They spend money, they do something which is
Okay.
to their detriment.
Right.
That's missing in a case where people have more land enclosed than they should. Estoppel would be like someone your next door neighbor mistakenly believing that this is the boundary line when it isn't,
And you know it.
and you
don't
know
say
it, and then
anything.
they build the crossing across
Okay, now I do.
the creek.
Yes, now I remember.
Yeah, that's what estoppel is about, where they, depending on your knowledge, or depending on you to do the right thing, basically.
Right.
Do something, spend money, make changes, because otherwise you simply have acquiescence.
Right.
And acquiescence is the basis of all of this. Where you've got you at least on one party you've got uncertainty about the boundary line.
Right.
Then you've got the other party who found out that, oh my goodness, I'm
Right.
closing and have been for quite some time.
Right.
So,
So to go ahead and let them build on your property, not saying anything, and then put up a fence on your property line. and
yes,
then
saying
you've got
thank
a
you,
nice new
thank you
building.
for the garden shed,
Right.
or thank you for the granny house, or something like that. That's estoppel,
Okay.
and you are estopped from doing
From
that.
doing that.
Yeah.
I see. Okay.
So they have to do something. If it's just you've got this enclosed and nobody says anything,
Then it's
then it's acquiescence, which is ripening into adverse possession.
right.
And basically, it's the clock is ticking. Who is being limited? Who is subject to the limitation statutes?
Both. I mean,
No,
if
one has the advantage.
with the title.
Well, they have the advantage with the title, but if they don't enforce their title
Right, then they're,
within that limitation period,
right.
they lose title.
But he's only got to wait the limitation time until
The
it-
possessor,
right,
the adverse possessor.
right,
The limitation is on the person with the title.
okay,
So that's the thing. It's the same situation,
just the both sides of it.
and the flip side of the law. It depends on which side of the fence you're on, how the law is being applied. The limitation statutes, that's for the person with the property,
Okay.
with the title.
They've only got so long.
Yeah,
to
they
make
only
sure
have
they
so
get
long
off.
under different circumstances.
Okay,
Yeah.
I see.
And, okay. Pages 292 and 293. The use of modern equipment. This is something that we go on and on about at the conventions. You get better and better gear, but are you getting better and better surveys?
Maybe not.
If you are assigned, someone hires you to survey 1,200 acres,
Okay,
and let's say this is 1,200 acres,
okay,
and so you come in the front gate here, and then you drive here, get your GPS, then you drive here, get your GPS, drive here, get your GPS, and then you drive over there and get your GPS for the corners.
okay,
Have you actually surveyed that track?
no.
Why?
Because you didn't establish the boundary of it, you just found the monumentation.
You found the corners.
Right,
What about things that are going on around
Between.
here
right,
on the boundary?
right,
And you get the same effect by someone setting up with a total station, say backsighting this pin. They set up in the middle, let's say this is a hill.
okay,
Set up in the middle, backside that pin, turn to that pin, turn to that pin, turn to that pin, and then check back in. Is that a proper survey?
no,
Because you have not determined the boundaries.
right,
And if there are fences, are they on the property line
Right.
or not? And so the same thing that was said in Stafford v. King is true today, and they're still quoting Stafford v. King. Which is, it is the duty of the surveyor to run round the property.
right.
And that meant running the instrument and running the chain. So, he has quite a bit in this book about what the modern equipment allows you to do great precision, but it doesn't help you to understand the issues that the prior surveyor was dealing with.
Right.
So that
If you just do the
Yeah.
four corner, you're not truly following the footsteps of the original surveyor.
No.
Right.
Using GPS, it's almost in central Texas,
Mhm.
almost impossible to get a reading on the corners because that's where all the trees grow.
Right.
Trees, they're kind of large bushes.
I have seen them.
They're tall and leafy and all that. And then you go down the fence line, you get another shot. I don't care if you're using a total station or what. This is why you did those traversing exercises
Right.
in math. So your figure closed before you ever shot a corner.
Right.
So you knew that you were accurate, and then you go along the fence line, getting and if you did that, would you know that you had tire tracks?
No.
Would you know that someone was using your land as a shortcut?
Right.
No.
Maybe not.
And you definitely wouldn't know about you might see it, but you might not see the gas pipeline sign there.
Right.
They take a dim view of you not picking stuff like that up.
Right.
So that's what you get when you run around the property.
Okay.
Okay. if it's in boldface type,
You should know it.
there's a reason for that.
Okay.
And the Judge Wheeler was way back when, 1856. That's even before Stafford v. King. You know, carelessness of the chain carriers, roughness of the surface, variation of the compass, imperfection of the instrument, unskillfulness in the use of it, and other causes, not to be enumerated, inevitably produce in every instance more or less of an uncertainty of result. And if we suffer ourselves to be governed by the compass and by the measurement, collisions will be incessant, which is that's a very, Victorian sort of way of saying that, the calculations take precedent or take second place to discovery of the monuments set originally. So, you can have the most perfect, precise gear and still not find the monuments. And that's what you're attempting to do. And 10 years ago, 2003, GPS was really just getting, it had been used since the 80s, but there just wasn't court decisions. There weren't enough precedents for using it for boundary surveying. So in Central Texas, we did most all of the surveys, acreage surveys, with a total station because it had years and years and years of precedents. And
When we
they
first
didn't
started
trust.
using,
They didn't trust GPS.
No, for a long time we didn't do anything but just pipeline center
Yeah.
line stuff with it because they were going to do an as-built
Mhm.
of the ditch anyway.
Yeah.
But all the boundary stuff was always done.
Always done with a total
Yeah.
station. And there's,
And we didn't do very much boundary.
with a field book, you have something you can take to court. With GPS, okay, have you ever generated a report on points?
Do you mean like proving that they are there?
No, basically, okay, you've got your control points,
Right.
and that's now your base station.
Mm-hmm.
And then you've got this corner here of the property, and then for good measure, you're doing RTK, but you're on it for 2 minutes straight, solid and all that.
Okay.
And what every program has, or every processing program has this. You can generate a report on the point, this point,
Oh, okay, I see what you're saying.
and it really looks official.
Right.
But it's still based on the very, that you can't get any better than the very worst conditions
Right.
when you're using GPS. So if this control point here was set badly, or was not processed right, didn't have enough occupation time, bad satellites, bad constellation, etc., this point will never be any better than that.
Right.
So, you knew that already. But essentially, GPS has changed a lot of things, but I see too much of that being done, where people are not going down. And, clients like it because the surveys don't cost as much anymore. But, who's going to get taken to court? Surveyor for failing to pick up that.
Right.
And that would be easy to miss. It's real easy to miss, tire tracks like that in thick brush. So anyway, it is now 7:10. I won't torture you too much more. You're going to see Kirby Lumber Company all over. They must have had, his brother must have been a lawyer, Kirby. But there's about 8 or 10 major court cases in Texas. Okay. Did I? Oh, I forgot to do that.
What's that?
I forgot to Well, we could spend the rest of the evening on this one, since the rest of the evening is approximately 7 minutes.
Okay.
What are the expectations of a surveyor in a retracement?
Like a retracement of the original survey or just of the deed? I mean, I guess that would
Well,
be the original survey.
Basically, the original survey creates that parcel.
Right.
It's
No,
not
I knew
the
that.
original
Not
patent.
the original patent.
So anytime you're doing a retracement, you're doing whatever survey created that parcel. You'd better be doing
I was going to say,
the creation.
so that'd be part
You
of
better
the
know how it relates.
expectation
Yeah.
is to locate it within the
Within the
parent
parent
tract.
parcel,
Okay,
yeah.
so you would have to see if the description has any monumentation and locate
Mhm.
that and run around the property.
Okay, that's,
And
you know,
to make all, I mean, to note all those things like that, the
Mhm.
fence, if there's anything coming
Yeah.
across it, any infractions upon the boundary or what have you. And then to make sure that the parent tract, be it the section or a
Mhm.
larger parcel or
so
whatever,
that,
is also
so that your
established.
tract is not going across the parent tract.
Right.
Which it can if it was taken
Well, if it
out
was
of
supposed
two.
to be that way,
If
right.
it was taken out of two patent
Sure.
surveys, or, you know,
But if it's just floating around and you haven't made sure that you know where it's tied down
Yeah.
to,
okay, other expectations. Use the right gear.
right,
Don't use stuff that's all worn out and isn't accurate.
right,
You have done your deed research.
right,
And it's nice working for someone who appreciates that,
hmm,
because that takes time.
right,
And you can't just pick it up from the courthouse, read it, and understand it instantly.
right,
You know, there's a lot of
right,
figuring
yes.
that goes on, and basically,
And this doesn't work, so I'll go a little further out. And this
Yeah.
doesn't work, so let me go a little bit further out. And then,
so basically, when you survey a tract, you're surveying that tract and into almost, yeah, you should be surveying into all the adjoiners,
right,
so that you can at least know that your line is
where it's supposed to be.
yeah. And you have done the deed research into the original.
Mm-hmm.
Okay, now you have, say, a tract that is in a subdivision that was created in 1956.
Okay,
And, okay, lot 13, lot 14, lot 15, looks like a postage stamp,
right,
you know, a little book of postage stamps. And then yours, the one that you are hired to survey, is 10 feet wider than
all the rest.
all the rest.
Okay,
And the one next to it is
10 feet
10
shorter.
feet short.
That stinks.
Well, what do you do?
I guess locate the original subdivision plat and see
Okay,
if it was
you
intended
got-
to be that way for some reason.
You got your
or-
subdivision plat, and
Okay.
it says postage stamp, postage stamp,
So
postage
it says
stamp.
they're all even.
It says they're even.
Well, what told you that one? I mean, was it the fence that was?
No, you measured
Made-
it. You found the
So
occupation.
someone
You
just
found
had a
10.
miscalculation when they said
Or-
those corners.
Or there's it's peaceful occupation.
Right.
What if
Somebody
someone
moved 'em?
bought? No. What if somebody bought 10 feet?
Oh, okay.
Where do you look to find it?
Who knows? You'd
You're
have to-
supposed to.
Well, no, I know, but I mean, if they
Where
filed it,
where do you go looking, and whose lot's gonna have it?
I guess the person who bought the 10 feet,
Usually that's the case.
and you would go to the courthouse first.
Yeah.
Maybe the abstract company. But if it's recorded, and if it's not,
Yeah,
then
the $64,000 question: is
Right.
it recorded or
that's
not?
what I meant by
Yeah.
who knows.
And well, yeah, that literally. And if you're working for the guy who's 10 feet short,
Mm-hmm.
the person who sold the 10 feet,
Mm-hmm.
that almost never gets recorded against his deed.
Right.
The person who buys it, if it's recorded on his deed.
Right.
So-
But then there's not a lot of proof to say, no, look, whoever owned this prior to you let
Mhm.
that go.
Yeah, and the piece of property that I'm trying to buy was bought by the old guy,
Uh-huh.
I'm trying to buy it in 1958. It's a one-owner house.
Wow.
And as a result, there wasn't, there's 2 out of 6 pins found, and they weren't correct either. Well, they were big nails, they were spikes. So, but anyway, luckily there was not any sort of problem with possession or with,
That's good.
the deed was just as clean as it could be. But anyway, read chapter 7. I will. We're gonna go forward. Oh, intentions of the party for the 4 corners rule.
Okay.
If that's not burnt into your brain, it had better be.
Okay.
How do you determine the intentions of the parties?
I know it. I just don't know it this minute. I know what I'm supposed to know.
Yeah. Where do you go first to determine the intentions of the parties? The grantor and grantee.
To the deed.
Yeah. That is this is really mind-numbingly boring at this point, but that is where you go to find the intentions.
Okay.
If there are problems with that, like major, like they couldn't possibly mean that,
Right.
issues, then you bring in other evidence. But the other evidence that you bring in cannot contradict something in the deed. It can only clarify it.
Okay.
So, the old guy who knows everything in the neighborhood and that you're getting parole evidence from him,
Right.
whatever he says, it can only be used to clarify things in the
Okay.
deed. It cannot
change
overcome, like if it calls for, 150 feet. He can't say that, well, that's supposed to be 175 feet.
Right.
Now he can say it's supposed to be 175 feet because the county abandoned the lane next to it
Right.
back when Higginbotham's barn burnt down, stuff like that.
Right.
He can clarify things, but he cannot overcome.
Gotcha.
So I think we're about at that point. You've got that written down.
Yes.
I will email that. I had all sorts of lovely things like a PowerPoint presentation.
Dang.
Big deal. So everybody will, luckily, since we're doing it this way, everybody has access to it.
Right.
There's Higginbotham. But anyway, that's it for October 3rd? 3rd.